Hi, I'm Dan Lagani with Silver Solutions, and welcome to this episode of AgeWise, the show to help make you a little smarter about the things that you and your loved ones need to know as you grow older. You know, we all seem to have some sense of what happens to us physically and even emotionally as we age, but today we cover a topic that is equally as important that we seem not to know nearly enough about, and that's the law, elder law to be specific. Our guest today is Britt Burner of the Burner Law Group, a boutique firm in the New York area specializing in legal issues related to the aging process. Before we speak to Britt, a little bit about her background. She's at the Burner Law Group, as I mentioned, but beyond advocating fiercely for her clients, Britt has done a lot of volunteer work in the sector as well with the New York City Bar Association, as well as the New York State Bar Association, where she's currently the treasurer of the elder section of the New York State Bar. Please welcome our guest today, Britt Burner.
Thank you so much for having me. I'm really happy to be here today.
I'm really excited about this topic because, as I said in the intro, we know a lot about aging, or at least everybody knows a little bit about a lot of topics related to aging. But the law is one of those that when we hear about it, it's usually very late in the game. So let's start with the most basic thing. What is the definition of elder law, and what areas do you actually focus on?
That's a great question. A lot of people really don't understand that in the end, elder law is a division of trusts and estates. When I meet with a client, first and foremost, we're looking at what documents they have in place to ensure a happy and healthy and strong future for them as well as for their family members. So when we're talking about estate planning and we're adding in an elder law part of that, we are looking at how they are going to age and have care if they need it. Are they going to be utilizing government benefits? And is there certain estate planning that needs to go into the preparation for that? Are they going to have long-term care insurance? Are they going to self-insure? And what supports are they going to need around them as they age to make sure that they are taken care of? And for many people, they want to make sure that there's a little something left behind as an inheritance or as a legacy to their family members or other loved ones.
You know, it seems like, again, we have this sense of, I need to put together a will. Some of us are a little more advanced and think about healthcare proxies and decisions like that. When it comes to the elder law piece of the trust and estate planning, when's the right time to start thinking about it?
When it comes to the elder law piece, I generally tell people it's a good idea to start looking into this maybe in your 60s. Some people are approaching retirement at that age. Some people have been retired for some time at that point, and some are nowhere near retirement or say they're never going to retire. But your 60s are a good idea. It tends to be the age where the focus is no longer on people's children and it's on their own future, and their children are maybe adults at that point, and things are starting to change a bit. So I'd say in your 60s is a really good time to focus on these things.
Talk to me about where elder law intersects with Medicare and the government.
Yeah, so Medicare is a health insurance program that individuals who were working, who paid into the system, have as their health insurance when they turn 65 years old. Many times my clients are very concerned that if they do planning that is going to allow them to be eligible for Medicaid, that is going to mean that they're going to lose their doctors or lose some of the providers that they've gotten very close to. And so when we're doing elder law planning, specifically planning for Medicaid long-term care assistance, either in the home or in a facility, we're talking about services that go beyond what Medicare provides, because Medicare is a health insurance and it's a great health insurance for many people. It doesn't provide that long-term care. It's not going to give you the 24/7 aid in your home. It's not going to pay for you to live long-term in a nursing home. So people who end up planning and going on Medicaid to cover these long-term costs are what we call dual eligibles. They are Medicare and Medicaid eligible, and they use both as different layers of health insurance.
So, Britt, it's a really great clarification on the question that I asked about Medicare, the element of Medicaid. What happens if I haven't planned in advance and now I'm entering a skilled nursing facility and haven't made the provisions necessary? Can you still help someone like that?
So I'm going to start with the disclaimer that I am a New York attorney and I practice under the laws of New York. And while Medicare is a federal program and Medicaid is a federal program, Medicaid actually is also a state program that is administered by the local counties. So anything that I advise clients on is New York specific, and New York has a very robust Medicaid program. That being said, attorneys across the country usually can assist people who have not done advanced planning. Certainly in New York, we can. And while we might not be able to be as effective, which is why we want people to be looking at things sooner when they're in their 60s and we like that advanced planning, there are usually things we can do so that not everything is turned over to either the nursing facility, the home care agency, and there are assets that are left available for the individual or for their family.
One of the things that you mentioned a second ago is that laws vary by state. Give us a sense of broadly the things that are consistent, if you can, across the country, and some of the nuance, for example, that may be different in New York than Florida.
Sure. So the documents that you should have are the same from state to state: a healthcare proxy, a power of attorney, a last will and testament, a trust, perhaps. Those are all documents that are going to exist in every state. But that being said, in some places they call a healthcare proxy, which is what we call the document that in New York that says who makes medical decisions if you can't make them for yourself. In other states, they might call that a healthcare power of attorney or some other name. So the names of the documents may differ. Now, if you have a healthcare document that is signed in one state, it should be effective in the other state. Although I often tell people who are true snowbirds or live fully in two places or are going to relocate permanently, that they should be seeking the advice of an attorney in that second place to make sure that all their documents are in order according to that state. The other big difference that I find is that when it comes to estate planning, the process of probating a will may be very different from state to state, and the laws are going to change on how that process works. And so while one estate plan might be appropriate in one place, you may want to change it based on the laws of the new state.
Can I ask the remedial question? Tell us specifically what goes into probating a will.
Yes, good question. So probate is, I always tell people, you can't have probate without a will, and you can't follow the terms of a will without probate. The two things need each other. And I think that's one of the number one misconceptions when it comes to estate planning. In New York, your will is probated, and that means that a petition is filed with the court with the original will by the person that you have nominated to be your executor. This is done after your death. And it's asking the court to validate that document, to say that that document is a true copy, a true original, and that you have signed it, and that the executor can be appointed by the court and go forward and follow the terms of that document. Now, that is going to require in New York that all of your legal next of kin be notified. So the most important thing is if you have two children, for example, and you're disinheriting one, well, that child that you're disinheriting is going to get a copy of that will, and they're going to be sent a citation that says, come to court on this day and tell us why you think there's a problem with this document. And so it invites problems, it invites litigation.
Is estate planning, is elder law only for the very rich, or is it something that people of all economic means should be looking into?
I would actually say the opposite, that it is best, the client that I can best assist in the elder law context is the client of modest or middle class means. That is the person who is unlikely to pay out of pocket or to be able to afford out of pocket the cost of long-term care, but also the person that has some assets saved up that they would like to protect. So the incredibly wealthy tend to engage in traditional estate planning because they either have purchased long-term care insurance or they have enough assets to pay for that care. But it is that middle class family that wants to protect their home to pass on to the next generation, or the small savings that they've built up over the years that really would be depleted very quickly if they were paying out of pocket for the care that they need, and perhaps would run out and be left with nothing.
So, Britt, I'm sure the same thing happens in the world that you focus on as the rest of the world. Things evolve and change. What are the biggest changes been over the last 5 years, and what are some things on the horizon that we may see that are different when it comes to elder law?
The thing that is most affected in elder law is that when we talk about Medicaid and we talk about planning for Medicaid, we are talking about government benefits. We're talking about programs that cost the government money. So certainly in New York, we have an enormous change in the law that's taken place, signed in April, will go into effect next week, with change in how they're assessing the amount of care people receive at home through the Medicaid program. And these are the changes that I think we're going to start to see in more and more places. Now, as I said earlier, New York State has a very expansive Medicaid program. So these cuts are necessary so that New York State can meet their budget. And that's the idea behind why these eligibility requirements are changing. But I think those types of changes are something that we're going to continue to see.
I want to shift topics for a second and talk about you and how you got into the area of practice that you're in. So what's your story, and how did you go from law school into this particular specialty?
It's very interesting. I am doing the exact thing that I swore I would never do. When I grew up, actually last week on September 15th, our firm marked a 25th anniversary. So 25 years ago, my mom started this law firm. All growing up, I swore I would never be a lawyer. I was 7 when my mom graduated from law school, and I never wanted to do it. I was never going to be what she was. I then decided to be a lawyer, but I swore I would never practice elder law. I then switched to elder law, and I swore I would never work with my mother. And now here I am. We've been working together for 6.5 years. So I don't know. Some people think I was destined to be here. I think life just brings you places you didn't expect to go.
We covered so many great areas. One thing that I always like to wrap up with is, if you could only tell me 3 things that we talked about today that are a must for anybody starting to look at the process of planning for growing older, what would they be?
Number 1 is make an appointment for a consultation and go see an attorney. I think so many people delay that appointment. They're scared. They don't want to face it. It's not scary. We're very nice people, lawyers. And the more information that you gather, the better you can protect you and your family. So number 1 is make that consultation. If you are someone who has already done some planning, have it reviewed. There's constant changes in the law, both federally and on the state level, when it comes to taxes and other issues that affect these areas. And so we tell people you should have your documents reviewed every 5 years, or if there's a major change in law or in your life, death, birth, retirement, purchase of a home, sale of a home. So that is an important thing. Review your documents. Estate planning and elder law is not a one and done situation. It's something that should be continually revisited. And the third thing that I would say is most important is to really have clear in your head what is most important to you. And realize that when you're meeting with an attorney, that you need to tell the attorney that, because everybody's situation is different. Everybody's goals and who they're looking to provide for and their desire for autonomy over their assets is going to be different. And so you're really going to want to be clear on that for yourself, and how to let the attorney that you're working with know that so they can find the best solution for you.
What great advice and a great conversation today. Britt Burner of the Burner Law Group in New York. Thanks so much for joining us as our guest on AgeWise today. If you like today's episode, please share it with your friends and anyone else that you think will benefit from it. And if you want more shows, you can visit our website, silversolutions.com. Just click the video tab and you'll see the entire AgeWise series there for your viewing. I'm Dan Lagani with Silver Solutions. For all of us here that like to help make growing older safer and less stressful for you and your family, thanks so much for joining us. Be safe and be wise.